Okay. Okay, we are live. Hello, everybody. This is Denise Davis, and I'm here today with attorney Douglas Noreen from Raleigh, North Carolina. And we're here today to answer some questions about probate. I get a lot of calls and a lot of emails, a lot of texts with people asking me different things. And as I have mentioned often, I'm not an attorney. So I thought it would be a good idea to bring an attorney in to answer some of the most frequently asked questions. So right now, I'm going to turn it over to attorney Douglas Noreen, and we'll, as we go along, ask some questions.
Well, good. Thanks, Denise. Happy to be here. As Denise said, my name is Douglas Noreen. I'm the managing shareholder of Howard Stallings Law Firm in Raleigh, North Carolina. I've been doing trust, estate, and guardianship litigation for, 13 or 14 years now. Grew up in the Raleigh area and went away for school and came back and settled here, and I've been happy ever since. So it's obviously a great area and a great state to be in, and I'm happy to practice in the area of probate and probate administration and probate litigation. So as Denise said, I deal a lot with the problems that arise after probate is filed. Being in the litigation world, that generally means I'm dealing with fights that occur. And so I've seen a lot of the, I'd say maybe missteps and things that have resulted in those fights. So happy to answer some questions and go through some things so that many of you may be able to avoid that and get ahead of some of those issues. So I'd like to start just with maybe 5 minutes or so on a couple of basics, just to make sure we're all on the same page. And then I think Denise has some questions that have come from the group, or our recurring questions she gets that she's going to ask, and I'll be happy to provide answers to. And then certainly if any questions come up as we go along, feel free. I think, Denise, can you get those in the chat and things like that if people jump in?
Yeah, that's what I'm looking at right now to try to do.
Okay. So just let us know. See if you can get comments to us, and I'd be happy to answer anything that comes up. So, but let me start, like I said, with a few basics. The probate process, just as we think about that and what that entails. So the probate process is obviously somebody has recently passed. Typically a loved one, a parent, sibling, something like that. And their estate needs to be administered, needs to go through the probate process. So what that means is that we are going to the courthouse in the county where they lived, and note if they went across county lines for kind of end-of-life medical treatment, that would not change that. It is where they lived, where their residence was. And we will file an estate file in that county. If there is a will, we would file the will in that estate file and get it probated. That is the fancy legal term that just means the court is accepting it as the will. If there is not a will, that's okay too. We would still open an estate file. There just will not be a will filed in it. You may hear the terms a testate or intestate estate. All that is designating is if there's a will or not. If there's a will, it's called a testate estate. If there's not a will, it's called an intestate estate. That's all that difference means. When the court opens the estate file, they will appoint somebody to be the personal representative of the estate. You may also hear the terms executor or administrator. People use those terms generally interchangeably, although they have some difference, to mean the person who is administering the estate. Their job is really going to be, it's a 3-step process. It's number one, collect the assets of the estate. So find out, where the deceased person had their bank accounts, if they had vehicles, if they had clothing, furniture, those types of things. Real estate's slightly different, but certainly we would look at what real estate that they had. So collect their assets is step one. Step two is determine what debts need to be paid. You may be aware of some, if this was somebody close to you, that they had a credit card or medical bills or a mortgage or a car payment. Those are kind of the most common ones we see, but of course there can be others. And so step two is determining what debts are out there. and paying those debts with the assets of the estate. And then step 3 is once that process has been done, once all the debts have been paid with the assets that are left, then the heirs of the estate receive the remainder as the inheritance. And again, that would be in a testate estate that has a will. The will would dictate who gets what. In an intestate estate that does not have a will, it would be the heirs at law. And the North Carolina law dictates who those people are. Generally, first in line, of course, would be a surviving spouse, then children, then parents, and then it goes out from there to kind of further kin away from you. So, but that is really the 3-step process: collect assets, pay debts, and then the inheritances to the beneficiaries. The only other thing I wanted to mention here at the outset is we're talking about the probate process. That involves probate assets. There are also a class of assets that are considered to be non-probate assets. So those are things that will not be assets of the estate or dictated by the will. Generally, those, if I had to simplify it, obviously there can be a lot of issues with that. But if I boiled it down, I would say that anything that has a written beneficiary designation. So for instance, if you have a 401k, and when you filled out that paperwork, you wrote down, I want, my wife or my children or my trust or whatever it may be to be the beneficiary. A life insurance policy generally is going to have a written beneficiary designation. Some brokerage accounts, if you have some investment accounts, things like that. Certainly a trust, if you've actually set up a trust and that has a written beneficiary. Anything that you have filled out a beneficiary form on, that is going to control that asset. So, and that can create, obviously I've seen a lot of disputes over that, right? So if I write, I want my wife to have my 401k, but then in my will, I leave it all to my kids, the estate, my probate estate to my kids, that 401k, the will is not going to apply to it. It's going to go to my wife because that's what I wrote on that asset. So those assets are considered to be non-probate assets. Again, we hear those terms a lot, probate versus non-probate. So something to be aware of as you're administering the estate and looking at a probate process is those assets are not part of the estate. The 401k, the life insurance, those will not come into the estate, will not be part of the probate because those are non-probate assets. So again, just a few basics and kind of some things to get us started and be thinking about. And then Denise, I'm happy, I think you had a few questions to ask me and I'd be happy to answer those.
Okay. I know I had told you 4 questions, but since you brought up the topic of the non-probate, I wanted to ask concerning real estate in North Carolina. So from my understanding, real estate is not included in probate unless there's not enough money in the estate to pay the creditors off. Is that correct?
That is exactly correct. Yes. And I don't know a lot about other states' laws, but I do think this is somewhat unique to North Carolina. So North Carolina treats personal property and real property differently. Personal property would be your things, your clothing, your furniture, your bank accounts, your car, kind of those types of things that you have in your life. Real property is commonly referred to as real estate in common parlance. So that's land, houses, things like that. And you're right. The way North Carolina law treats those is that upon death, your personal property will become owned by the estate. It goes into the probate process. Like we talked about earlier, the estate can use that to pay debts, so on and so forth. Maybe the estate needs to sell a vehicle to create cash, things like that. That's all common. Real estate, real property, does not, does not go into the estate. It becomes immediately owned by the heirs. You're also right there, Denise, that if the estate then does not have enough money to pay its debts, there is a process where it can bring it in. It tells the court, court, look, we don't have enough money to pay all our debts. We need this piece of real property so that we can sell it to pay all our debts off. And the court will approve that. Mm-hmm. But short of that, the estate has no interaction with the property. The problem I most frequently see with that is that people don't understand that, and they use the estate assets, for instance, to pay the mortgage or pay the property insurance or property tax. Well, because that asset, like I said, is not owned by the estate can't pay those things. That to the court, when they're reviewing it, they see money going out on an asset that is not an estate asset. Usually we can fix that. Because that is a quirk in North Carolina law, the clerk and the courthouses see that error quite frequently. So I mean, it's not the end of the world, but if we want to kind of cross our T's and dot all our I's, we do need to keep aware that that real property, that real estate is not an estate asset. You're correct.
Okay. All right. The first question that I get a lot of phone calls, and they'll ask me sometime, my sister is doing this or my brother is doing this. The family or the heirs, they disagree on what should be done. So how should it be handled if they can't come to an agreement?
Yeah. So this is a loaded question. There's a lot of ways families and heirs can disagree. And to some extent, it depends on what the disagreement is arising out of. But I can give a general kind of answer to this question. The first thing I would say is, I know we're premising this question on the fact that it hasn't been able to be worked out yet, but to the extent that the family can come together and work this out, even if it's difficult, that is always the best solution. Before money gets spent on, frankly, on attorneys fighting these fights and feelings get hurt and all those kinds of things. If there is a way forward that, even if it's not ideal and everyone has to give a little bit, but if there's a way to figure this out amongst the family before it turns into all of that, that is always the best solution. So give that every opportunity. Sometimes that's not feasible. If that's not feasible, when it comes, again, it kind of depends on what the dispute is about. I would say that the personal representative of the estate, either the administrator or the executor, tends to have a lot of power in these types of situations. If it's a dispute over who's going to get which heirlooms, who's going to get what property, so on and so forth, as long as the value is equal to everybody, and a lot of times those family heirlooms, the monetary value might be relatively low, but of course the sentimental value is very high. But the personal representative has a lot of discretion to make those types of decisions. And so depending on if you're in that role, then that may empower you. If you're not in that role, that may be discouraging. But the court has to appoint somebody to be the decision maker, and they have appointed that person. Now, if there's a concern that the personal representative is acting unfairly, is doing things underhanded, is favoring certain beneficiaries over others, those can all be reasons to remove somebody as the personal representative and get somebody else in place that may act more fairly or something like that. So those are some thoughts, but again, I'd come back to if the family can work it out, that tends to always be the best.
Mm-hmm. And does it make the process longer if you do need to have somebody removed? Because like I said, I get a lot of phone calls and they'll tell me that the administrator or the executor, they're not communicating with them. They won't tell them things. They feel like they just have been totally left out. And I know that is a part of the responsibility of the administrator or the executor. So, but if they want to take it to court and try to remove this person, is that going to make the process like months longer, or what happens?
Yeah. So that is a court proceeding. The court has appointed somebody in that role. If we want to remove them, we file a petition. We go back before the court and explain why, and the court will either agree or disagree. It is, I'd say, that process, start to finish, is probably 2 to 3 months. So you are going to add some time to the administration. Now, if one of the concerns is that nothing is happening or it's happening too slowly in the scheme of things, that may accelerate the administration, but it is certainly going to add some time. Yeah.
Okay. All right. I have a question from Wayne Scott. So he said that his mother had terminal cancer at the age of 76. And I guess at that age, or somewhere close to it, she set up an IRA account and made his sister the beneficiary.
Yeah.
His mother has passed, he's the executor, but he's saying that I guess he feel like the account should not have been started due to my mother's condition. So is there anything that can be done about that?
Yeah, happy to talk about that. And let me just say, I'm happy to answer specific questions. I don't know everything, certainly about Wayne's situation or any other questions that come up. So this is generic legal advice. Certainly, I would recommend if you want to go further, getting an attorney to really look at your case and make sure they understand all the details before you rely on kind of the generic advice or comments I'm about to give. So just to be careful about that and make sure we're all on the same page. But could you do anything about that? Yes, the answer is yes. So, the law presumes that anytime anybody signs a legal document that it is valid and they had the capacity to do so. That's kind of the baseline, that assumption, anytime anybody signs a document. If we think that wasn't proper, whether it be her cognitive condition was not of one that she would have understood what she was signing, whether the sister that you mentioned, who's the beneficiary, was somehow involved in that signing, involved in the setup of that account, whether this is somewhat rare, but I have had a couple of forgery cases where we think it's actually not her signature, something like that. Those are all reasons that we could challenge that document. And if we were to be successful in court about that document would be invalidated. And it would, in essence, revert back to whatever was the situation prior to that. Now, because this is an IRA, as we kind of mentioned a moment ago, that is a non-probate asset. So likely this, any legal action about this would not involve the estate. It would be directly between the heirs, whether that be Wayne here or any other siblings who would have taken, and the sister. The estate is probably not a party. Again, depending on the specific situation, that may change.
Okay. All right. And I'll be sure to put your contact information in, just in case anybody want to set up a consultation with you afterwards.
Sure.
I do have another one, Lim Turner. He just states that his father owned land in North Carolina, but he lives in Georgia, and the father lived in Georgia. So I guess this would be an ancillary probate that would need to be filed. But he's stating that there are so many confusing forms. So in a case like this, I guess it would be good to speak with an attorney.
I think that's right. So what would happen here is that, like I said, the estate gets open where the person was living when they died. And so, Lem, if your father was living in Georgia, then the estate would be open in Georgia. Now, what that means, as you just pointed out, is, when it comes to real property, people are always concerned about title, making sure they have proper title. And title is all recorded with the Register of Deeds or at the courthouse in the county where the land is. So if we have an estate in Georgia, but the land is in North Carolina, there's nothing to link those together. And so what we do is we file an ancillary estate, which is think of it as kind of a sub estate. We're not doing the administration of the estate. The administration is happening in Georgia, but we file documents showing the Georgia administration in the county in North Carolina as an ancillary estate, which would show here's how title is going to pass. Here are the heirs. Looks like in Lem's situation, we have 50-50 heirs. So it would simply reflect that. It is one filing that happens in the local county here in North Carolina. The rest would continue to happen in Georgia. And Lem, I can read these comments, by the way. I see them popping up here. Lem, I see you also said that the real property is different than a car. Yes. So as we kind of chatted about a moment ago, something like a car that would be personal property does become owned by the estate, whereas real property, land and houses, real estate, commonly referred to as, does not become owned by the estate, but becomes immediately owned by the heirs. So it is a little different.
With the ancillary probate, is the process as far as the paperwork the same? So everything is the same. It's just that it's because it's in a different state, they're calling it ancillary. Is that correct?
So it's a little different. it's frankly, it's easier because the true administration of the estate is going to happen in this case in Georgia. So we don't need to redo the whole administration here in North Carolina. We're not doing two separate administrations. We just need something of record in North Carolina to show how this title is going to pass, who the heirs of the estate are, so that that's public record. And if they were to later go and sell this land, or they pass it to their heirs later on, that record is on the public record in the county, so people know who owns that land. So it's easier. It's much easier, an ancillary estate. It's not as involved as a full probate estate. I'm not aware that there are forms out there to file an ancillary estate like there are with some of the probate things that we do. I would recommend one of two things: either contacting the local county and the estates division of the clerk's office. They may be able to help and walk you through that, or retain counsel to help you through it. That part is not a difficult process.
Okay. All right. So I'm going to move on to the second question that I had told you I wanted to ask. And it says, what happens if you're not named as the heir or beneficiary? I'm asking that because I have people who called me. In fact, someone called me not too long ago, said that they just found out about the probate case and they were not listed as an heir. And so they want to know, what can they do in this case?
Yeah. So this question largely depends on kind of the timing of everything. If the estate is still going on, then it's relatively simple. We would file a pleading with the court or file a notice with the court that you are a beneficiary, and the court will make sure that they address that and determine that before the estate is dispersed. So on that, if the estate is still being administered, it's relatively simple to kind of throw your name into the hat and make sure it's considered before the estate is closed. If the estate has been closed already, obviously this becomes a more difficult problem because the estate assets have already been dispersed out. The estate no longer is holding anything. And so if somebody is a valid heir that was not considered, the other heirs that did receive property are going to have to put back into the pot to then share with this potential new heir. So that becomes a little more difficult. We would be looking to reopen the estate. Since it has now been closed, you can reopen it and then file what I kind of mentioned earlier, throw our name into the hat, have a court decide that. And if court decides we are the heir, the court would order the return of certain property from all the heirs that received it in order to create your share. And so it's possible, but again, that process is a little more complicated. Certainly, if you find out about this while the estate is being administered, you probably want to act relatively quickly to get your name in the hat there. The other thing I'd mention on this one is that, again, with the personal representative, the person administering the estate, if we think they did this on purpose and maybe maliciously, and maybe there are other things that we can point to, I'd think about whether we need to remove that person if they're not acting fairly. That could be a factor. I'd probably want to see maybe another example or two that we can point to, not just that, but it would start me thinking about that.
Mm-hmm. Mm-hmm. Okay. Sounds good. Wayne Scott, he made another comment. Can you see that?
Yes. Let me read this real quick.
Mm-hmm.
The court's looking for. Okay, so I think if I understand this question correctly, we've administered the estate. We are getting towards the point of closing the estate, and maybe submitting a final account. So generally for commissions, the court is looking for a request for those and an order where they can approve them. And once the court has approved the amount of commissions, then we would put it on a final account. So I'm wondering if what happened here potentially is that we prepared a final account that showed the commissions, but we hadn't taken that step of submitting it to the court and having the court approve it first. So just that it's kind of a two-step process, and it sounds like maybe it got all jammed together into one here. But we do need to get in a separate request and order by the clerk, get the commissions approved before we would include them on a final account.
And the commissions, that's what the administrator or the executor get paid for managing the estate.
That's correct. And it's a percentage basis. It's 5% of the receipts and disbursements in the estate. Up to that, the court has authority to approve that. The court may approve less, but that's the generic calculation. So the amount will depend on how big the estate is.
Okay. All right, Wayne, I hope that helps you. The third question that I had for you is, what happens if someone gives away the assets or spends the money before probate is either started or completed?
Yeah. So one of two things would happen. We would first be looking to get the money back or get the assets back. And whoever opens the estate, whoever's the personal representative of the estate, as we talked about at the beginning, the first step is to gather the assets. So if they've kind of scattered to the four winds, then we need to try to chase them down. In some situations, that's not feasible, right? Either they've been spent or they've disappeared, or let's say property was validly sold to a third party once they have purchased it, unless it's an insider deal, they knew they were kind of doing something wrong. If they've purchased it for value, then it's now theirs. And so we wouldn't be able to go get it back. If that's the case, we would have an action against the person who gave it away for, in essence, to make up the difference in cash for what it was that they gave away, because they didn't have the authority to do it. So they've done something wrong and they need to make the estate whole.
And I've had like people call me and say that a family member, or say a sister or brother, was actually took the money out of the bank and was spending the money. And I was wondering, how could that happen? Because I thought, let's say if the loved one had a bank account and had money in it, that it would have to go into an estate account. So would the bank be liable?
No, you're exactly right about that. What I'm seeing more and more nowadays, and I wonder if it would have been one of these two scenarios, is if the bank account was solely in the deceased's name, then you're right. When they pass, nobody should have access to it until the estate gets opened. Then the personal representative can go to the bank, say, here's my proof from the court. I'm the representative of this estate. I need to take possession of this account. Otherwise, it should not be touched. But what I'm seeing is, a lot of times towards the end of life, somebody who's maybe dealing with some medical issues or something like that, add somebody to the bank account. They add a child to the bank account, maybe for the purpose of, well, I just want you to write the mortgage checks. I want you to just pay the light bill. And so in order to make that easy, I'm just going to add you to the account. What they don't realize they're doing is that when you have joint owners of a bank account and one of them passes, the account now belongs to the remaining owner. And so, it affects the estate plan and the inheritance in a way that I don't think a lot of people realize. So if you have multiple children and you add one to your bank account and then die, well, that bank account now belongs to the one, not to the 2, 3, or 4 of the other children that may be there. So I would wonder in that situation if something like that has happened. You can also name, like we talked about earlier, with a 401k, with a life insurance policy where you have a written beneficiary. Some bank accounts are now allowing that. And so if the person had a written beneficiary on the bank account, then it would pass to them. It'd be considered to be a non-probate asset, even though typically a bank account is a probate asset. So I would wonder if one of those two things happened in a scenario like that.
Okay. All right. And the last question that I have for you is, do you have to file probate if the decedent has been deceased for over 2 years?
Yeah. So I'm going to give the very prototypical lawyer answer to this one and say it depends. My recommendation generally in all scenarios is to file probate. And the reason I say that is it provides some finality in the legal world to claims. When you file, like we talked about earlier, those 3 steps where it's collecting assets, paying debts, and then inheriting, giving the inheritance to the heirs. Part of paying debts is the estate runs a notice in the local newspaper, and it runs for 90 days. And that's how long people have to submit their claims against the estate. So if there's a credit card, if there's a car payment, something like that, if they don't submit their claim within that time period, then they are barred. They no longer can get their money from the decedent. So, now after 2 years, if nobody has come forward, maybe the odds that they would at that point are low. And I'm, understanding of that and sensitive to that. My advice would still be, let's just make sure. And so I would advise to do it. Now, for real estate, there's also kind of a real estate component to this question. Generally, any buyer or any title insurance company who is looking to buy a piece of property that's coming through an estate, if it's within 2 years, they are going to require an estate to be opened or have been opened. There is some language and some guidance out there that after 2 years have passed, title insurance companies will give title insurance even without an estate being opened. And so there is that's why that 2-year time frame gets added into this question, is for that reason. It's the real estate reason. So, if it's been past 2 years, you're relatively certain that all debts have been covered or nothing is going to come out of the woodwork. The one I always worry about the most is the IRS, of course, but you feel like you have a good grasp on that, and either the real estate question, somebody is willing to insure over it after 2 years, or say there's maybe no real estate with the deceased. I could see maybe not filing. There are times where it just wouldn't be worth the expense, but from a kind of a more conservative position as far as making sure we're being safe, I would tend to lean towards doing it even after 2 years, if there's any question.
Yeah, because my very first probate case, I knew nothing about probate at this time. And I had listed a lady's house. She actually lived in Tennessee. We spoke over the phone and she asked me to list her house in Rocky Mount. Listed it. We got a buyer. A few days before closing, the attorney contacted me and said, we can't go through because she never put the house in probate. So I was like, what is probate? So anyway, he explained it to me. But what he told me to do, he said, well, she's 4 months away from hitting the 2-year mark. He said, so just take it off the market, wait the 4 months out, then put it back on the market, and she won't have to go through probate.
Yeah.
So that's what we did. We waited the 4 months out. We put it back on the market. We got a buyer and sold it. So that's why I always wondered, because like I've spoken with other people and they had told me their attorney said they have to find one person. I think it's been like maybe 10 years. And said that their attorney said they still need to file probate. And so I was like, well, I know the attorney told me just wait the 2-year out, since we were so close to it. And we did, and we sold the house with no problem.
Yeah. And the answer is, you don't have to. Once you hit that 2-year mark, especially if you're dealing with real estate, you're not required to. It becomes a judgment call at that point of, the potential risks that we haven't wiped out all creditors, so on and so forth, versus the cost of it. Like I said, if we're relatively certain we know of everything that needed to get paid and we don't feel like there's going to be any surprises, maybe it's a cost we don't need to incur. So it just becomes a judgment call. If it were 10 years later, unless there was a particular concern, I would probably say there's no need at that point. That's certainly anybody who has owed money either has forgotten about it or whatever. But it's just a judgment call past 2 years.
Yeah. And after 2 years, other than the IRS, can a creditor still come forth and try to make a claim? If
you have not administered an estate to cut them off, then yes.
Okay, so they have to have been notified either through the newspaper or send them a letter or something. They have to be notified. Right. One way or the other. So if they're not notified, they can come forth.
Correct.
Okay. All right. Well, I highly appreciate you coming on today. You have shed a lot of light onto things. I don't think I see any more comments, but let me put your phone number. Let me just put your name in here.
Sure.
And like I said, I'll be and what is your phone number?
Sure. It's 919-821-7700.
So that was 919-821-7700.
That's
And
correct.
Noreen, is that Noreen?
That's correct.
Okay, let me just stick that up here. So if anybody wants to schedule a consultation with you, I guess they can call that number. Is that a good number for them to call to schedule a consultation?
That's right. Yeah, call that number. Either myself or some member of our staff would be happy to speak with anyone and answer any questions, and we can go from there.
Okay, all right. Well, I really appreciate you coming on, and I really hope you'll come back again and share some more insight into the probate world with us. And it was a pleasure having you on.
Thank you. Yeah, thanks for the invitation. I enjoyed it.
Okay. I'm gonna hit the end screen, the end stream, but you and I'll still see each other after this, okay?
Sounds great.
Okay. All right. Thank you for everybody that watched and that asked questions. I hope you learned from this. Then if there's any other information, you can still leave it in the comment and I'll see if I can get an answer for you. Y'all have a good day.